in order to prove fraudulent transfer, which in other words, if you're a creditor and you want to reach an asset that's been moved away from the defendant, so you've got your judgment and you want to go ahead and start collecting, you find out that an asset's been moved away, well, you have to prove that it was moved away intentionally to avoid you. And you can prove either that the actual state of mind of the debtor was, you know, I knew you were coming and I moved this out of my own ownership to avoid your claim. But Eric can tell you, Eric's the litigation attorney here. We're Eric and Gary here. Eric is constantly litigating these claims, and one thing that's not obvious to a planner like me or the general public is that it's very hard to prove that someone intended to avoid a particular creditor. You have to really show their state of mind, and you have to go through these badges of, you know, there are these indications of fraud. It's very difficult to do. So most claims that we've really been associated with, and most of the cases in reality, take the approach of proving fraudulent transfer constructively. And what that means is in each of these state statutes for fraudulent transfer, you can prove that if someone shifted assets away and didn't get something of equal value back and then became insolvent, that you don't have to show what their intentions were. Even if they actually didn't intend actually to move something away from a creditor, if you can show that they didn't get something back that the creditor can get and that they became insolvent, you typically can prove fraudulent transfer. So what we're dealing with today is the insolvency side and the fact that proving the fact that someone shifted something away and didn't get back reasonably equivalent value. Those are your two factors to prove constructive fraudulent intent. That's kind of the backdrop. We have this system whereby we're giving a seminar, and you can, is it an email, Eric? It's an email in, and we see your email?
In the webinar, you can drop questions. So during the time, and this is Eric Boughman, by the way, and with Gary Forster. And yes, during the next hour, if you have questions, you can drop them right in the question panel.
Is that where they log in?
Yep, and we can see it right here. And somebody actually, we have an initial question, will slides be available? The answer is yeah. You should be able to see slides. If anybody can't see slides on their screen, please let us know. We will also drop into the box here to share the outline for today's seminar. And it will cover, actually, it'll have more detail than the slides.
Yeah, it's almost the same, but it'll have some cases and some outlines. We're using several screens, so let us know if you don't have the PowerPoint up on your screen, because the system is a little difficult to navigate with respect to us knowing what you're looking at. And the paralegal who usually takes care of this is out today. So if you have a technical issue, just send us an email. Eric's pretty good with that, and we'll try to fix it. I think we can pretty fast. So that's your backdrop. The backdrop is I want to get to the asset. I can't prove that the transferor debtor, you know, intended to avoid me. I don't know what his state of mind was. So I'm going to prove that he transferred this valuable asset out that I need, that I want to collect on, and that he didn't get anything back that I can get, and that he became insolvent. And what that basically means is he didn't get anything back that I can get, and his debts exceed his assets, so I can't get any other assets. So practically speaking, he became creditor-proof by transfer of that asset. So what we're going to talk about today is, what is creditor proof? What is insolvency? How do we prove that someone didn't get back reasonably equivalent value when they transferred something away? It's a subtle issue, but it's a tremendously effective strategy in terms of planning as well. So when we started, okay, here we got you should be looking at introduction and overview, and so we're now getting into the keys to proper planning, and then how valuation works, what standards should you use, you know, when you do the planning, you should always think about, well, if someone looks at this, what kind of defense could I establish now before there's any clouds forming or there's any issue? And then we'll wrap it up with some practical comments, and then we'll take questions. Should go about 40 to 50 minutes, and then we'll take questions.
And let me, because we had a couple people I see that have logged on a little bit late, and just to kind of make sure everybody's on the same page, if I can, Gary kind of gave an overview of what we're going to talk about today with respect to how valuation plays into asset protection, and we have a brief overview here. And in previous webinars and seminars, we've spoken about the issue of timing and late-stage transfers. That was our last webinar. If anybody missed that, let us know. There actually is recordings that are available. And so today we're talking about the value issues that come up, you know, other ways to approach asset protection when, you know, the average person typically doesn't come into any type of planning with no debts, with no obligations, no potential obligations, and oftentimes people start thinking about asset protection when they've had something dramatic occur from a financial risk standpoint that actually makes them think about it. And so we're going to talk about all of those issues, and I'll work the slides, and if you have a hard time seeing anything, please let us know. And Gary, back to you, sir.
Okay. Go. I think we covered that.
Yep.
So what we want to start thinking about is when we create an asset protection plan, we typically fund. We take exposed assets and we fund trusts and LLCs, domestic and offshore, depending on the person's particular circumstances. And we're going to start talking about issues that should be considered when we do the planning. Also, you're going to see cases regarding people that weren't planning. This is just basically what happened, you know, in the fray of things when someone makes a transfer, and how does the valuation of the asset and the determination of insolvency play a part in whether or not the creditor can go get that asset.
So when we're looking at these valuation issues, going back to, you know, how plans are unwound. Plans are unwound when somebody makes a transfer. From, you know, generally speaking, one of the primary ways plans are unwound is when somebody makes a transfer in the face of a financial crisis or risk. So they're making a transfer of less than reasonably equivalent value, and they're doing that in a situation that leaves them unable to pay their debts or insolvent. So we will talk about both of those. And
well, so that's how you prove fraudulent transfer without having to show that the person intended to avoid you. They'll be deemed to intend to avoid you if they didn't get back something that the creditor can attach. They transferred, didn't get back something of value, and they became insolvent.
So reasonably equivalent value, and reasonably equivalent value is not necessarily fair market value or equal value. And Gary, you want to elaborate on that a little bit?
Well, as we'll see with a lot of these cases, you basically have two issues. One issue is, you know, a lot of different litigants have tried to frame what value is, and the court, I would tell you, this is one of the few areas where I think the courts have been pretty common sense about it, pretty practical about it. And basically what you're going to see is that when someone transfers something out, they better get something that the market, the general market, perceives as of similar value. So it is kind of a fair market value, and that the creditor can attach. It's not necessarily equal value, or as we're going to talk about, you know, there's all kinds of tax and accounting determinations of value. It's not really going to be necessarily related to that. It's going to be a determination of whether the defendant became uncollectible based on the transfer.
So now here's something to consider with reasonably equivalent value is the timing. If you're trying to, just consider a situation where you're trying to sell a property, or you need to raise cash and you want to sell your Rolex watch. Well, if you've got a week to sell it, you've got to run through pawn shops and Craigslist, you're likely to get considerably less than if you had plenty of time to get it cleaned up so it's like new and try and sell it to the best bidder. Any property is like that. So timing's a consideration, and it's something that courts consider. If somebody's trying to raise cash quickly, they may only get 50 or 60% of fair market value, and under the circumstances, that may be sufficient value. But the question the courts look at is, are you making a transfer to try and avoid creditors, and what are you doing with the funds that you receive, and what's the perspective from which you receive? What's the utility to creditors of any value that you receive in exchange for any transfer? Are you using that to pay your debts, or are you using it for some other purpose? And I'll jump on. Gary, you could talk about this next issue, and this, just elaborate a little bit more on the perspective with the example of like LLC Equity or something like that.
Well, one thing that we've seen a trend to, and I think Florida, you'll see this, for example, and in the old, really, and new Fraudulent Transfer Acts, is that that the creditor will determine, what has value and what doesn't have value. In other words, you can't, like I just wrote a section of the new Nevis LLC Act, and as an example. So as an example, the Act says, okay, if someone funds a Nevis LLC, right, and they get back an LLC interest, 100%, let's say it's a single member LLC, that is considered the same value, and that there is no perspective of a difference between a creditor and a debtor. But that's a problem for a creditor. That's why I put it in. It's a problem for a creditor. It's an asset protection haven, that LLC statute. So we basically added all we could in terms of something that would attract people to fund an offshore entity in a protective way. So in the States, that's not the trend. In the States, the creditor is going to claim, well, wait a minute. We know you put $100,000 into an LLC, and you own the LLC. So when you show me whether or not you're insolvent, you're going to put your LLC on there. I still have a $100,000 asset, except there's one problem. The creditor can't reach the asset. So there's a trend toward ignoring, when you determine solvency, and this reasonably equivalent value issue, which is how you prove fraudulent transfer, toward making that determination from the perspective of the creditor. So if the creditor can't reach the asset that's coming back in, it's basically dropped from the asset side of the solvency determination, which is a huge issue. So you can't really avoid paying a debt, and claim, okay, you can't prove constructive fraudulent transfer because my assets and liabilities haven't changed. Because the problem is that the assets, although the value may not have changed, the value from the creditor's perspective is completely different because these assets are not reachable. So if you are a creditor also, it's basically a way of tipping the scales to prove that, hey, this guy transferred this out. He may have gotten an entity, part of an entity that he funded, but I can't reach it. So I can prove to you that he didn't receive back reasonably equivalent value because the value doesn't count, and he became insolvent because all of those assets are not counted in the solvency determination.
Now, there's a new proposed act dealing with fraudulent transfers. We've talked about this before. Gary and I wrote an article for the ABA on it if anybody's interested. This is the Uniform Voidable Transactions Act of 2014. It has yet to be adopted in Florida. It has been adopted in some states, and just a note that that act actually has some language in the commentary that suggests that resolves this issue of value, and basically says that an asset that does not serve some utility to a creditor would not be considered reasonably equivalent value. So in the LLC example, trading your exposed cash as a contribution in exchange for an interest in a protected LLC would not be reasonably equivalent value, even though it might be equal value in other contexts. But if the creditor can't attach that asset, it's not going to be reasonably equivalent value. So I think
that's the trend.
Maybe we, and yeah, that's where the courts are going to interpret, I think, based on the language in that statute. So now we get into some other, I think, really cool areas, especially from kind of a financial standpoint. And this is looking at this issue of solvency. And when we talk about solvency in the asset protection context, we're talking about one way to look at it is whether a creditor, or excuse me, a debtor is paying debts as they come due, and the most common way to look at it is just whether the value of the debtor's assets is greater or less than the debts of the debtor. So it's balance sheet solvency, and that's what the courts look at. But when we're looking at these issues, you're going to see that there's some distinctions from accounting, and specifically with respect to GAAP. The courts have noted that GAAP is not controlling. It might be relevant, but there's several areas where GAAP veers from, or where the law veers from GAAP analysis. And the reason for that is generally that the judges don't want to be told how to interpret the law, not by accountants, not by the authorities that promulgate GAAP rules, but instead the courts want to make that analysis on their own. So certainly they can consider GAAP and consider expert testimony and accounting analysis and financial analysis as potentially relevant, making their decisions, but the courts are going to make these final decisions.
And the reason for that is that that GAAP, we probably have some accountants on the seminar, but these GAAP standards, and now you have international accounting standards, are so that if somebody picks up one set of books, they can pick up another set of books that are under the same accounting system and kind of know with some accuracy, on audit standard, that what they're looking at is under the same format, and they can create this uniform means of preparing balance sheets or valuation, really. The judges don't want to get into uniformity like that because you're always going to get skewed depreciation issues and this type of thing. They want to know that whether or not this asset is available to the creditor and what it's worth to the market. If it had to be sold, what's the value? So I think the court's got this one right, actually.
So now when we're looking at solvency analysis, a situation that we see a lot is, one example was recently a doctor comes in and says, okay, I think I've got a claim coming. We've gotten a demand letter, and we think we're going to see a malpractice claim. I don't think I did anything wrong. The hospital is going to back me up. The insurance company doesn't think I did anything wrong, but I've got this potential exposure out there. And on top of that, by the way, I also have a pending divorce, and I have to deal with those issues. So then, the question is, we've had clients come to us that have been referred from other attorneys where people say, well, you've got these open issues, so you can't do anything. And that's just not really the case. What we need to do is make sure we account for these open issues, and when we're doing that, we get into a detailed analysis of, okay, well, what's this potential claim that you have? What's your exposure? What's the likelihood of that actually arising and becoming a debt? And how do we account for that? And that's what we're going to talk about over the next 20 minutes or so. And so we'll define contingent liabilities, disputed liabilities, and the same with respect to assets. A quick note, especially for the accounting audience, the issue of hindsight. Oftentimes you're making analysis and you're doing, taking protective steps and doing planning, and then it comes back later, 2 years or however long later, when it's now being challenged in court, and some of the assumptions that we made we're now able to determine whether or not those assumptions were true or how accurate those assumptions were made. And so this issue of hindsight is one that the courts look at, and the courts are all over the board on this. Some courts will consider hindsight to determine whether or not assumptions are reasonable. Other courts will say, the only thing we can really look at is, step into the shoes of a debtor at the time they made certain assumptions and determine at that time whether those assumptions were reasonable. Two different standards, and we'll talk about that a little bit more. Another thing to be aware of the courts look at here is this probability discount rule, and that basically is the court saying that the fair value of the contingent liability should be discounted according to the possibility of it ever becoming real.
And from a planning perspective, there's some real value in getting this stuff taken care of up front. In other words, if in fact there's a liability that's probable or contingent, it's very impressive to the court. It's just like you're doing a gift tax return or a estate tax return. It's very impressive to have an appraisal. So when someone comes into the office and they say, well, in case this does ripen, okay, I want my plan to hold up. And my plan's not going to hold up if I've got assets less than liabilities, because it looks like, I'm doing a constructive fraudulent transfer. But we don't think that this case is going to come to fruition. That's one question. Is it going to happen? The other question is, well, how big is it going to be? So what we do is that we have a study done, and that study says, okay, there's probably a 10% chance, and the range of exposure is between $1 million and $2 million, or whatever the actual thing comes back as. Well, because no one has a clue, usually, exactly how these cases are going to pan out. If, in fact, the client is later sued on an open liability, this thing that we had this study on, well, I mean, when they try to figure out whether or not a fraudulent transfer occurred, who do you think is going to be ahead of the curve? The guy who says, okay, no, you got to go use hindsight. This is what happened, and he should have known it. Well, there's no way he could have known it. So what he did was he did a study. He tried to figure out his exposure, and he left some assets behind, or he basically covered that exposure, and it didn't make him insolvent. And we looked at it, and we had a professional assess the exposure, and we planned based on that. So there was no running away from this claim. Therefore, there's no intent to avoid the claim, and it's very hard to show constructive intent to avoid the claim, because we acknowledge the claim, we had a study done, and we know the exposure. So there's no insolvency. It's very, very powerful. If you think about it, what do you think the judge is going to do? The judge is going to ask for a study. Oh, we had a study done. Oh, well, you weren't intending to avoid it. No, we understood there was something, and here's was the exposure, and we planned around it. It's very powerful.
So let's use a fun example. This is actually analysis that came out of one court decision, and here's the scenario the court threw out here. So say that so company A, we just use these generic names for the companies, but one company's value is $1.7 million, and that company guaranteed a big loan to company B, $28 million. And then the court says, well, let's assume when this was the argument that was made to the court actually, assume that when the obligations were guaranteed, there was a 1% chance that the guarantee would ever be enforced. So if company A is conducting an analysis, or let's just say you're doing this from a personal perspective in connection with some asset protection, you've got a business and you've got to figure out, well, what's the value of my business and how do I account for this claim? So it could be a real estate investment, it could be any business where you have one company, maybe you have a holding company because you've already done some planning with Gary, and you've got a holding company, and a bank says, well, that's great that you have this single asset entity that's going to borrow money, but we need to get some value from somewhere else, so we're going to make you and your other company guarantee the loan. Very common situation. So how do you create or come up with a figure for the value of this $28 million guarantee? And so I like to do this in a live seminar just to kind of see what the answers are, because there's a couple different directions to go. But what the courts said in this particular circumstance is that the true measure of the liability was $17,000. Now, I'm sure that this was probably after hearing from a very eloquent expert who gave the court some basis for the financial analysis. But you know, in the asset protection or in the corporate restructuring context, if you were trying to say, well, you moved assets to avoid this debt, and that company can show that, well, we did some restructuring, but when we did the restructuring, we still had, you know, $50,000 in cash, enough, you know, operating cash from month to month. You know, if you can get a court to say that your liability was only $17,000, the true value of this guarantee of a $28 million loan was only $17,000, well, then you've got a great argument to defeat any type of fraudulent transfer claim. So you can still, even in the face of a very large guarantee like that, a very large contingent liability, you can still do some potential planning as long as you're careful about it. You go through the analysis ahead of time. And then, you know, another way you could look at it is you could say, well, even if it was a $28 million liability, and you know, with a 1% chance, you might make an argument that assumption, that loan guarantee was a $280,000 liability on your books as far as the fair value of that contingent liability.
Yeah, they got to 1.7 because the total assets of the company were only 1.7. They call that 10%, 100, what was it, 17,000.
And that was a 1988 case. It was actually in a bankruptcy court. We pull a lot of these cases for the bankruptcy courts because they do this analysis more than anybody. But whoever made that argument and won that point did a fantastic job in that case, and got a nice result for their client. So let's move on to talking about, you know, kind of defining some of these different value issues. And so contingent claims, this is generally a liability where the value is reasonably certain, but the liability may or may not arise. And the typical example is in the guarantee context. As long as the primary obligor performs, you never have an obligation. But if the primary obligor does not perform, then the guarantee may come due. Another situation is with, you know, if you have collateral and the collateral is insufficient to cover the loan balance, you may have liability that comes due.
Yeah, and who are you guaranteeing? What company? How solvent are they? You know, have they defaulted? You know, what kind of collateral supports that loan that you've guaranteed? You know, mom and dad were guaranteeing all these loans in the 2000, you know, what was it, 4 to 2006, and they didn't think a million years that the house would ever be worth less than the loan. And so you had all of these outrageous claims on guarantors during that period. I think a lot of that stuff could have been discounted. I don't think a lot of those really, in terms of if you could have planned around those guarantees, I don't think a lot of those assets really should have been reached, because the value at the time of the guarantee was pretty, the exposure was pretty limited.
Yeah, the collateral value and the ability to perform by the primary obligor. And so, you know, again, timing is almost always a factor in these as well. If somebody comes in and they say, if we're doing some planning for them, and Gary will usually be doing the planning, and then I do the litigation side here in our office, but we'll talk about these things together. We'll say, okay, there's this, you know, these debts out here. So we look at somebody's financial structure, either, you know, an individual or their holdings and the companies that they have, and we see that there's some guarantees that they've made, which is not uncommon, some lines of credit that they may be obligated on. Well, the way we account for those, if the person comes in and they're you know, fully solvent and flush with cash and business is good, is likely going to be a lot different than if they come in and say, look, I don't think I can meet my obligations next month. Well, if you know that that loans are about to go into default, and it's likely that a bank's going to start calling guarantees or calling loans, then again the obligation is going to probably have a different value. And we would really, frankly, in our business, we're lawyers, so we're not going to try and figure that out. What we're going to do is we're going to go get some type of financial expert who's going to come in and give us those figures and tell us, well, how do we properly value this stuff? So this is kind of some meat and potatoes stuff of a lot of the people who are listening on these seminars, the accounting folks that we have and valuation people. This is where we turn back to you for advice on how to handle these, and we just tell you what the courts look at. So Gary mentioned this issue of collateral, and there was an interesting case. So when you're looking at collateral, how much, in a typical, let's say, just the real estate market from several years ago, when everything crashed, loans were traditionally for homes and personal residence was traditionally 80% loan to value. So property that was worth $100,000, banks would lend $80,000 on it, and so you had a cushion to cover any loan default in case the loan didn't get paid and the property had to be sold to settle the loan. When property values crashed by split in half or even worse, and suddenly had a $500,000 house with a $400,000 mortgage, and now the house is worth $250,000. People could never pay the mortgage to begin with. If the property forecloses, you end up with a deficiency judgment, and then the bank turns to the individuals to try and collect that, and the individuals have engaged in asset protection. What kind of defenses do they have? And we have a case that actually gives us an example of that it's a pretty recent case, and it's on a pretty common but large scale.
It's a large exposure, and it's a very interesting fact pattern, actually.
Do you want to give the background on this? This is a 2016. This is actually a case that's been going on for a while. BB&T v. Hamilton Greens. It was an interesting 2014 decision, and then this one's out of 2016.
On the same case. I guess it's the same. It's really the same.
It's several
case.
Decisions that the court's been making as BB&T has been chasing actually a guy named Ballinger, and so they've filed several motions going after Mr. Ballinger, and most recently they went after him as a guarantor on a $3 million construction loan default, and so the bank sued, and
they sued him as a guarantor. Now there were several other guarantors involved, and there was a very large property involved that had crashed in value. But it was very interesting as the case developed. The first round of the case, where they initially tried to go after Ballinger, he had funded an offshore trust. Really, it's not something we would do, but really as part of the chaos, he funded an offshore trust. When we first looked at this case years ago, I mean, it really was pretty obvious that he was moving to avoid this whole disaster. It seemed, we're not sure how it was handled on the creditor side, but it seemed like a pretty straightforward case. I think a few things might have been missed when they first started to go after Ballinger on behalf of BB&T. So they came back. That kind of got swept under the away. I think they ended up, it wasn't completely dismissed, so they ended up coming back. He had this huge construction loan that he owed. He had a few $1 million in this foreign trust, and they wanted this money. But it was pretty interesting because although it looked kind of like a circus, where he was shuffling money off and he had some kind of health problem and they were coming after him, really, though, what was interesting is you still have to prove intent to avoid the creditor at the time of the transfer. So you always have to remember, although it might devolve into a circus act, at the time of the transfer, this guy was, if I recall right, he was really the developer. He was the organizer of the investment and the development of property. And the big money came from the investors. And they had indemnified him from any claim associated with the property or the loan. And the property was worth, what was it, Eric? It was much more than the loan.
Yeah, he testified that Yeah, now understand, this guy transferred his assets into an offshore trust. It was what was the timing on this? It was actually, I think, after the loan went into default, and right around the time that the lawsuit was filed, he's moving money in the trust. So it looks on its face to be clearly a fraudulent transfer. But yeah, he testified that the property was at one point valued at $15 million, and so then he said, well, it's a 15. It was, you know, at the time I made the transfers, this was a $15 million property. There were several other guarantors
that were going to indemnify me also.
They were supposed to cover this debt, so I had no reason to ever think that I was ever going to be called to pay any portion of this $3 million loan default.
So there's your intent to avoid. And then the solvency, you know, I got reasonable value back, I went insolvent issue, is a tougher issue because he still had a lot of value in the property. He got back a very large chunk of this hugely valued property at the time. So looking back at it, his argument was it wasn't a fraudulent transfer because you can't. I mean, I think his attorney handled the case very well. I might agree with that. Eric might agree. And I'm not sure about the other side, but very well in that the focus of the judge was pushed back to where it should have been, where, okay, we understand it looks like a pretty much a maniac issue, but what happened at the time of the transfer? At the time of the transfer, the property still had a lot of value. It wasn't underwater. I, therefore, had a lot of value, so I'm not insolvent, and I didn't intend to avoid anybody. Now that the property's crashed, it looks like, you know, everyone's trying to grab whatever I was planning with, but that's not the case. And he won the case. At least at this point. Is it completely gone yet?
I think that the last round, this 2016 decision, I think put, I don't know that BB&T is going to have many more options because they're not going to get to that offshore trust. This was their chance to crack the trust. They're not going to do it. So it's probably, for all intents and purposes, he's out of the woods.
Well, they would have to put him in jail.
Yeah, well, they won't have him. He won't move the assets back. He probably lost control of them when he put them into the trust, if the trust was set up properly, and so they had to figure out a way to get that money back. The way to do it was through some type of fraudulent transfer claim, and that claim failed because they weren't able to show that he made a fraudulent transfer. We had a similar situation. I really like this issue. I was hoping to go kind of establish the same thing with a court in South Florida. We had a client who had invested in some undeveloped property on the southeast coast, and this was right around the time of the real estate crash again, 2005. He originally acquired the property. The bank refinanced it. This was about $1 million, call it $1 million property. So the bank refinanced it in 2008. And when the bank refinances property, as most people know, the bank typically goes out, they get the appraisal or they commission the appraisal. So he's not appraisal shopping. The bank gets the appraisal, and surprisingly, when I look back on it, if anybody who can remember 2005, 2008, property was going down, the appraisal came back higher. Undeveloped property's crashing all around. So now, he started out, actually it was around $800,000, and then the value of the property was up to, $900,000, and that was 2008. And in 2009, he made some transfer. He set up some trusts. He had a kid, and he had some other things going on. And so he made some transfers, and he ended up getting sued on this property because he wasn't paying the mortgage. The property ended up selling. It didn't sell. The bank ended up getting it back in a foreclosure action.
But it had a value of like $40,000.
Where they came in and they actually showed that it was worth $25,000. And this was right around the time we got. So he was represented by some counsel in South, and there was nothing to do. He had defaulted on the loan, so there's only so much you can do with that. But then now the real battle starts. So okay, the bank gets a foreclosure judgment, takes the property, and now they go for a deficiency judgment. The way you prove up a deficiency judgment, you say, well, we have a $1 million loan, and we just sold the collateral, or we got a value on the collateral because we weren't able to sell it, and that value is $25,000. So now we have a $975,000 deficiency. And so they wanted to pursue him on there was a $900,000 plus deficiency judgment. And it was one of the arguments that we were making was, well, hey, wait a minute here. You're looking back. You're saying, okay, here in this was 2014, the property you say is worth $25,000 and he made transfers, and so it was a fraudulent transfer. But at the time he made those transfers back in 2008, 2009, your client, the bank, had just gotten an appraisal that said this property was worth almost $1 million. So how is it a fraudulent transfer? Why would he ever expect to be coming out of pocket, on a $900,000 judgment? We never got a court decision on that. We ended up getting a very favorable settlement out of that case. But that was an argument that we were able to raise, and I think it probably helped us get the settlement that we got.
And there's some of these cases that we'll kind of work through here in the last few minutes. Basically, say that you really need to look at the perspective at the time of the transfer.
And so, we talk about contingent claims, so disputed claims. Really, the difference here is, this is your personal injury claim, your malpractice, environmental claims on real estate, claims where you're disputing the liability or the amount, the value of the claim, or both. And again, these are subject to valuation concerns. And here is where hindsight might be more applicable, because a court may say, well, if you're driving down the road and you're on your phone, you're texting on your phone and sending pictures and whatnot, and you rear end somebody and it causes a big accident, you cause damage, and then you say, well, I disputed the claim, I didn't think I was liable. Well, that's not going to be reasonable. And frankly, a court probably doesn't need hindsight to see that that's not a reasonable assumption. But you can see there's certain situations in the disputed claim context where hindsight could actually have some application. And litigation context, there's a case, again, this was out of a bankruptcy court, where a certain company was forced into bankruptcy, and they had set aside some funds to settle asbestos claims, and there was multiple. These were claims that were being made all over the country, and they didn't have enough money. They got forced into bankruptcy, and so you get this situation where the company that's making these that sets aside money but gets forced into bankruptcy. Now a court goes back, they're in bankruptcy, and somebody says, well, we want to take a look at these, any late distributions and compensation you paid to your owners and officers, and see if there's any potential recovery here, because if you dissipated the funds of the company, we might make an argument that it was, they were fraudulent transfers, avoidable transfers from the company to these individuals, and we're going to pull them back. And in bankruptcy, that's very similar to how we see it in the asset protection context outside of bankruptcy. And with respect to those claims, the court in that particular case said, really what we're doing here is we need to go back and step into the shoes of the creditor, and at the time they set aside funds, make a determination as best as we can today to determine whether or not the assumptions they made at the time with respect to the value of these claims was reasonable. And so that's really how the court, and you can see that this leaves a lot of room for argument and really expert analysis and planning. And that's where the lawyers and the professionals come in, and that's where we really do our job. Just to touch on assets, nothing really new based on, just again, there was one case, and we don't have it listed here, but a company called North Point Communications and sued AT&T, and they got forced into bankruptcy while the case was pending. And one issue was whether or not they were insolvent when they made certain transfers, but they had a claim pending against AT&T that ultimately paid out several $1 million. And so that's one example of a contingent asset. You've got a lawsuit you filed, you believe it's valid, and you're going to win, but sometimes companies in the midst of litigation get forced into bankruptcy. Well, how do you value that asset? Here's one of interest. We've got, well, I want to leave time to take questions, but
this goes back to our point.
Yeah, this is an example here of where IRS rules and other accounting procedural rules might differ from how courts will do an analysis. So the issue in this case with EBC was the value of certain retail merchandise that had not been sold. So one party says, well, it's book value. The other party says, well, we had intended to sell it at retail value, so we should sell it at retail value. And what the court says is that fair value is a different concept than other accounting concepts when you're looking at it in the legal context. And what the court ultimately said is that you have to look beyond not only just the asset itself and hard and fast rules, but look at the condition of the company. And if there's a company that's on its deathbed and it looks like it's going out of business, well, go back to one of the initial points we made. If you have to sell something right away and it's a fire sale, there's likely going to be a lot less value for that than if you have time to sell it under normal market conditions. And that's what the court very wisely in this case, I think, said was, you know, you need to look at the entire circumstances of the case before you make a determination what the value is. And so I want to give Gary a moment here to talk about, you know, in doing planning, you know, how to kind of, you know, incorporate these concepts into your long-range asset protection plan.
Yeah. So, you know, a lot, I would say at least 50% of the clients that come in have some kind of guarantee or contingent liability, or there's some small issue that they're involved in depending on their profession. So there's this nest egg approach, which basically is an incorporation of what we've been talking about in terms of valuing and exposure. So if they have a balance sheet and either some of the assets with someone, maybe they have business interests, etc., it's unclear, they should get that all valued. And besides that, if they have a liability, if they know the liability, it's easy. If they have a liability that's contingent or they have a liability that's disputed, let's get it valued. Let's incorporate that into the balance sheet. And if it's possible that it's very large and that asset, that liability could cause insolvency, even by $1, let's say it could cause insolvency by $10,000. Let's go ahead and expose intentionally some asset or some portion of an asset so that we're not insolvent at the time of transfer. And that's the nest egg approach. Most people do it anyway. As you can imagine, a lot of the planning cannot be universal. There's usually some asset or some partnership or something that we can't protect. So it's usually pretty easy to do, and that's kind of the planning associated with value, long-range solvency it's called. And that's it. Does anyone have any questions?
And by the way, if you type questions or if you have any questions at any time, even after the webinar, if you shoot us an email, our contact information is on the handout that we've dropped into the chat box. So hopefully everybody can get that handout. Feel free to email us at, you know, it's our last name, Boughman or Forster, F-O-R-S-T-E-R, Forster at fbl-law.com, or Boughman, B-O-U-G-H-M-A-N, at fbl-law.com, or if you just look up FBL Law on Google, you should find us. But, you know, back to, you know, Gary's point, what I call from a litigation context is leave, you know, it's kind of the sacrificial lamb. You know, you got to leave something out, because if you try to hoard everything in a plan, that's where you're going to get in trouble. But we'll wrap up here. You know, just the takeaway from all of this is we want folks to understand that you can't avoid existing claims. You can't come in and say, well, something bad just happened, I don't want to pay it, how do I hide my assets? We just can't help you. But the fact that you have a potential claim existing, what we might be able to do is sit down and say, well, wait a minute, is this really a claim? Is it going to be a claim? Consider all factors, you know, insurance, you know, who else might be liable, all the things that we discussed today, and try and figure out the best plan to protect you from having anything else bad happen and pile on. And the key is, you know, proper planning, proper, you know, consideration of these things in advance is always the best way to approach it, rather than waiting for a rainy day to figure out if your umbrella works. With that, we're at you know, a little over 50 minutes. We've got time for a couple questions if anybody has any. Have anything pop up, Gary? Anything you would add?
No, this is the fourth of 11 commandments, mostly directed at planning through a view to litigation. So we have cases now that are really starting to define the area of asset protection. When you go to law school, there's no class on asset protection because it's really a developing area. And I think as we get toward the end of this series of 11, you'll find that the body of law is really starting to define itself, and it's really become a very viable area of practice.
And thank you all for joining us. By the way, next month we'll be doing another webinar. It'll be our the fifth commandment that we'll introduce. We are also producing a series of articles on these topics, which will in some cases elaborate a little bit further on some of the cases. So if you have an interest in that, look out for that, or please feel free to contact us. And then by June, we should be back on our, April and May have been a little bit shorter months for us, where we haven't been able to do the in-house seminars as well. But by June, we should be doing the in-house seminar, and we do those on the third Thursday of the month, typically from 4:30 to 5:30. We have a full dinner spread, and we make it a nice social occasion as well as a little bit of learning, and it qualifies for your accounting continuing ed credit. We also have this qualified for the financial planners continuing ed credit, the CFP credit, and also the lawyer's CLE credit. So if you need that information, please contact us, and we'll make sure that you have all the information you need for that. Otherwise, with no questions, we're going to sign off. Thank you, everybody, for joining us today. And let me just double check.
Have a nice weekend.
Oh, hold on. We have a question. All right. Do the courts permit the use of discounts for lack of control or marketability in fair value valuations for determining fraudulent transfer?
Sure. I mean, it's those discounts come from tax work that actually have to do with fair market value of an entity that transferred as part of an estate. So if grandma sets up a family limited partnership and gives 10% to grandkid, and the partnership has $1 million in it, typically, depending on the assets, typically the gift will not be $100,000, and that's because the actual valuation of that $100,000 is discounted because it's not worth as much as an interest that with that interest comes control. So when you give a non-controlling minority interest, it actually is worth less, and that should definitely be a factor in terms of the solvency analysis.
Yeah. And I will say I do as well a fair amount of shareholder and partnership litigation and corporate litigation. And when we're arguing over company splits, 51% is generally worth substantially more than 49% of any company. So courts consider it in all contexts, and there's no reason they wouldn't consider it in this context. As you can see from our discussion, a lot of this really is as much art as science. A great question. Thank you for that. All right. And that takes us to almost noon. Thank you, everybody, again for joining us, and have a great rest of your day. Bye-bye.